Of that number, more concerningly, approximately 90% of British Muslims do not have valid laws in place, according to an Islamic fintech company. The UK HMRC collected approximately £7.5 billion in inheritance tax in 2023-2024, compared to £7.09 billion the previous year. It is worth noting that if assets are not claimed, then they can end up with the royal family, known as the Crown, or the government treasury, who last year collected £10 billion. We all have a part to play to ensure any amount, little or large, ends up with the rightful and beneficial places. Some of you may know me. For those who don't, I'll give a brief introduction to my law firm, ALHQ Law and More. I'm Syed Aminul Hoque, founder and partner at ALHQ Law and More. Having previously worked in banking for over a decade, I was searching how to use my legal qualifications and financial experience to do work which will benefit the community at large. I left the corporate banking sector and became an estate planner, supporting clients with large and small estate planning needs. My wife, Aminul Hoque, co-founder and partner at ALHQ Law and More, has been a qualified solicitor since 2010, working at commercial law firms in London and Hampshire. She has the Islamic religious qualification for the fiqh of inheritance. In our team, we also have consultant solicitor Maya Hassan, who is a qualified barrister in Nigeria, and she is qualified with experience in Islamic contracts and inheritance. Yasmin and Munaya are both in the Sisters Hall to take any questions from our sisters. We also have a team of legal ambassadors locally and nationally to support our work, and today Tanzibur Rahman is here to help us also. We are grateful for our achievements in setting up our law firm in 2021. Alhamdulillah, we were awarded the Will Writing Firm of the South and Community and Charity Champions at the British Wills and Probate Awards, and receiving international recognition by STEP as Beauty Law Firm of the Year. All of these legal awards are celebrating our faith-inspired foundation, where we encourage all of mankind to be active in estate planning for success in this life and the hereafter, whilst our company plants a tree for every transaction and has a net zero website. Our head office is in Southampton, and we have offices available across the UK and internationally, supporting anyone with UK property or bank accounts that fulfill Sharia compliant instructions. Our website also contains information resources, and I hope today, inshallah, you will go away with enough information to improve circumstances for yourself and your families. Now we will look at inheritance and estate planning according to the Quran and Sunnah. Imam Sahib has gratefully given us a good introduction. Every soul will taste death, of course. In Islam, it's something to remember often and be positive and grateful for the life we do have and the breath we take. We should approach estate planning with positive and empowering thoughts that Allah subhanahu wa ta'ala has given us guidance on how to be successful believers. This is different to others without Islamic knowledge, who may be worried, have anxieties, or try to delay this actually noble endeavour. We enjoy talks like this where we can share our knowledge and help us work together to make necessary improvements with a positive Islamic mindset, inshallah, covering the blessings we have whilst acknowledging there is accountability for every action. As such, we should tie our camel on these matters for maximum success from all angles, inshallah. And unfortunately, an important hadith reminds us that there are only three things that are known to benefit a person when they are no longer in this world. One, a pious child, inshallah, that prays for us. Two, any beneficial knowledge that we leave behind. And three, sadaqah jariyah that we have specified. And it is with this, number three, that we can help you here today, inshallah. Initially, the advice on inheritance, will writing, estate planning, with lasting powers of attorney was revealed Surah Al-Baqarah. Then Surah Al-Nisa was revealed with more specific guidance and instructions, with further additional verses reminding us of our duties and obligations on this topic. We will not have time to go through all of the verses, but I will highlight a few important points in Surah Al-Baqarah, verses 180, 181 and 182, where Allah subhanahu wa ta'ala says that this is an obligation on those who fear Allah, and reminding us that Allah is much forgiving and most compassionate. Then also in Surah Al-Baqarah there is instruction to ensure provision for wives at verse 240, and at verse 282 a command for guardians to dictate injustice which is not possible without something called lasting powers of attorney. The default instructions are then in Surah An-Nisa, verses 3 to 7, verses 7 through to 13, and then 176, which identifies specific distribution of named heirs and the designated shares are explained. The order of payments, which is debts, expenses, gifts, and distribution, is actually the same as English law. In Surah Al-Ma'idah, verse 106, another reminder is made about making bequests, which is what you leave behind. Our Islamic guidance was revealed over 1400 years ago, and English law came into effect much later in the 1800s. As a community, we lead our families to goodness by following the commands and instructions in our faith. Across leading Hadith collections, you will find chapters dedicated to inheritance. No state or nation applies a uniform system of inheritance, which can be used as a reliable comparator, and some or all of them have included aspects of European law too. It is not for us to judge on the correctness of any legal approach. However, we should try to ensure any steps which we take are valid from an Islamic perspective. And for this, you can contact your respected local imam and religious scholar for support and guidance to understand these religious laws. Our legal team is qualified to support you, covering all schools of thought and with professional advice and regulated documents to ensure that the default legal rules do not cause hardship or difficulties for our community members. Narrated Syed Aminul Hoque, I was stricken by an ailment that led me to the verge of death. The Prophet ﷺ came to me, paid me a visit, and I said, "O Allah's Messenger, I have much property and no heir except my single daughter. Shall I give 2/3 of my property in charity?" Prophet ﷺ said, "No." I said, "Half of it." They said, "No." I said, 1/3 of it. They said, "You may do so, though 1/3 is also too much. For it is better to leave your offspring wealthy than to leave them poor and asking others for help." The reference is as given. Here is a diagram of the hadith where there is 1/3 which can be gifted freely. It is referred as al-wasiyah, which can be for non-Muslims, non-prescribed relatives, and or for any charity, or as a means to cover any unperformed hajj, unpaid zakat, or unfulfilled fasting, unless that has been factored in as a debt instead within the document. Then, for 2/3 of the estate, the shares and the heirs are confirmed for us, or the entirety of the estate if desired. Muslim majority countries have the benefit of this within their state succession system. In the UK, however, and slightly different for Scotland, a will is most certainly required for the whole estate if looking to fulfill your faith-based Islamic instructions. Abdullah ibn Umar radiallahu anhu narrated that Allah's Messenger sallallahu alayhi wasallam said, "It is not permissible for any Muslim who has something to will to stay 2 nights without having his will and testament written and kept ready with him." Abdullah ibn Umar radiallahu anhu responded that a night did not pass since he hearing this hadith from Allah's Messenger, sallallahu alaihi wasallam, except that I had my will written beside me, references given. If we adopt these actions, it will inshallah have a transformative impact on our families and communities. If we can return to this level of determination and focus to fulfill the Sunnah amongst our young and senior generation, it is truly a good thing today. Narrated on the authority of Abu Hurairah radiallahu anhu, the Messenger of Allah sallallahu alaihi wasallam said, "A man may do good deeds for 70 years, but if he acts unjustly when he leaves his last testament, the wickedness of his deed will be sealed upon him, and he will enter the fire. If, on the other hand, a man acts wickedly for 70 years, but he is just in his last will and testament, the goodness of his deed will be sealed upon him, and inshallah he will enter the garden." Reference is given. Writing the will correctly with care can truly be a golden ticket with Allah subhanahu wa ta'ala for redemption. Narrated on the authority of Abu Hurairah radiallahu anhu, the Messenger of Allah sallallahu alaihi wasallam said, "O Abu Hurairah, learn about the inheritance and teach it, for it is half of knowledge, but it will be forgotten. This is the first thing that will be taken from my nation." Reference given. We are here to ensure you can learn, inshallah, and share this beneficial knowledge, but also to take action on it and recognize that this is something that is very relevant for today's world, just as much as it was back in the special days and times. Let's take a look at the practical example you see on the screen here. On the left is a percentage distribution for a person that has left behind a wife, for example, a daughter and a son, including the difference when they make use of the 1/3 optional content. The wife is eligible in this scenario for 1/8, which equates to 12.5%, and the son is eligible for 58.34%, and the daughter is designated 29.16%. On the right is the percentage shares if the 1/3 option is being utilised. Now let's look at the example of a sister leaving behind a husband, 2 daughters and a son. The distribution is with the husband being eligible for 25%. The daughters have 18.75% each, and the son is eligible for 37.5%. Also, again, this will vary if that 1/3 optional part is being utilised. The final practical scenario is leaving behind a parent, a wife, a daughter, and 2 sons. So that's a parent, wife, daughter, and 2 sons. It is useful to note here that the mother or father, regardless of gender, get the same designated share percentage of 16.66%, with 12.5% for the wife, 14.17% for the daughter, and each son has 28.34%. Here also those percentages would change if the optional one was being applied. So the shares are very specific here. As you have seen, the calculations are intricate and detailed and have been admired by many leading academics, and notably the divine justice and equitability of the Islamic rules of inheritance have been correctly and widely appreciated by many non-Muslim scholars. Professor Rumsey of King's College London, an eminent barrister during the 1800s, stated about the Muslim law of inheritance as follows. Muslim law of inheritance comprises beyond question the most refined and elaborate system of rules for the devolution of property that is known to the civilized world. So to summarise, the rulings we have covered so far, first is that writing a will is a compulsory Islamic duty and an obligation for all Muslims. Ensuring you follow the correct Islamic rulings for your own circumstances is essential to ensure you achieve justice and fairness to all, to gain the maximum reward in the hereafter. There are so many different scenarios applicable within each family, and the state will specifically needs to, the estate needs to be discussed and prepared for. Having lasting powers of attorney in place for yourself and all your Muslim family members is also a compulsory Islamic duty and obligation. Otherwise, how else can you legally act as guardian for your loved ones? Sadaqah Jariyah is the only item which you can have any control over now as to its benefit in the hereafter for you. By making the intention to please Allah subhanahu wa ta'ala in the following specified commands, you will be on a path to success for this life and the hereafter, inshallah. Without informed advice from qualified religious and legal specialists, you are more likely to make an error or cause unintended consequences. Whether we like it or not, we are subject to many known but also unknown laws. And whilst people may have been knocking on your door about general elections to help form a government, it is very unlikely that you will find anyone coming to tell you to write a will or sharing with you the importance of such vital documents. Instead, you have to take the lead to work together and prepare something by working together. The basic requirements of English law that have to be satisfied are as follows. The testator must be identifiable, must be at least 18 years of age, be of sound mind, and ideally, then everyone from the moment they are 18 can be proactive about estate planning. It must be the last will, previous wills and codicils must be revoked. The will must be in writing, dated and signed in the presence of and attested by two witnesses who are not themselves a spouse or beneficiary within the will in one gathering. Administration of the estate will be assisted by clauses which appoint executors and or trustees, which can be friends, relatives or lawyers, appoint guardians of minors, and authorise professional charges where appropriate. The Islamic element provisions have to be clearly and validly expressed. This is very important. In the absence of a Bayt al-Mal, which is an Islamic treasury benefiting the Muslim community, the residuary clause can specify one or more charities, and if more than one, then not proportions. If it is an overseas charity, it is important to identify it clearly, where the value of the estate is potentially in excess of something called the nil rate band, which we will look at before the end. It is important to bear in mind that only bequests to registered charities will be exempt from inheritance tax. There are some default rules in English law which become activated if you do not write a will. Please have a look at the table of intestacy rules, which is available on the Gazette website, and you can see it on the screen as a flowchart of steps. Legal rules of intestacy, survivorship, taxation, property, and safeguarding apply to all assets, possessions, children, and vulnerable adults. Without a grant of probate, which is a certificate obtained from the court after death, you may be restricted in handling the deceased's assets, any shares, policies, or pension schemes. It becomes expensive, time-consuming, and stressful if no instructions have been left which are legally enforceable. Now let's take a quick look at UK tax rules and reliefs. Again, all these matters can become complex to navigate, and it is recommended to take specialist advice on your own personal circumstances. First note, each person has an inheritance tax-free allowance of £325,000. All transfers to spouses, husbands, wives, are fully exempt from inheritance tax. This means that without a will, every person has a potential tax bill if the estate exceeds £325,000. But with a simple will, this can be avoided. It is more complex for an Islamic will, but it is still possible. With the residential property, there is an additional tax-free allowance known as the residential nil rate band. And this is available when the testator owns their own home and intends to leave this to their lineal descendants. And this supplements the inheritance tax allowance by a further £175,000. With careful tax planning within a well-drafted trust will, which is different to a simple will, it is possible to leave behind a tax-free inheritance of up to £1 million and protect your assets for your children in the event of divorce or if remarriage occurs. This requires a severance of any jointly owned assets. There are reliefs ranging from 100% to 50% for business assets if there are commercial properties in a person's estate. However, buy-to-let properties are not included in this. The normal rate of inheritance tax remains at 40%, but can be reduced to 36% if leaving more than 10%, 1/10, to charity. All sums to charity are tax-free. Foreign assets can be included in an English will, but the recommendation is to prepare one in the country where the assets or bank accounts are located. Depending on the country, the tax advice can vary, and accidentally setting up your assets to be liable for UK tax is not a suitable outcome. So, why do Muslims need an Islamic will? To summarise, you may hopefully now have a good idea on why it's important that Muslims need an Islamic will. Essentially, everyone who does not want to follow the English rules of intestacy and would like to use the available tax exemptions and reliefs should prepare a will. For Muslims, specifically to make a declaration of faith, the Shahada clause should be included so there is no doubt or dispute on that important matter. To ensure if anything happens to you that you have appointed Muslim guardians for your children, especially is significant if going to perform Hajj. It is also important to do so to appoint guardians, as in the absence of doing so, the local authority could take children into temporary care until it is established who is to look after the children on a permanent basis. We have to follow the Quran and Sunnah as prescribed. Finally, it means that gifts to charity can be specified to Muslim charities or your local masjid, and you need to find out the registered charity number and substitute ones or alternative clauses to include this. A will is needed to acknowledge your funeral and burial wishes, which again can assist in progressing steps quickly and without dispute. This means having clauses for the ghusl, the kafan, the janazah, and the dafn. The will can also set out post-mortem instructions such as non-invasive autopsy. As such, instructions are not legally binding, and in any case of serious concern, it is possible to prepare what is known as a statutory declaration, and this is legally binding. It can be retained with your will as a separate document. During the lifetime, if you suffer an accidental illness which results in loss of mental capacity, it is important to already have in place your lasting power of attorney documents for both health and welfare and property and financial matters. Most people are surprised that technically the next of kin, a spouse or an adult child, does not automatically have the legal right without LPAs, lasting powers of attorney. Here is a short diagram to show a potential tax liability on first death. Taking what we've learned about the Islamic rulings and and also our knowledge of the legal rulings, let's take a look at this diagram and how it ends up with a tax liability of £141,250. So, without having a will, the guidance is 1/8 of a husband's estate to go to the wife, £121,875 of the total estate of £975,000 is inheritance tax-free because of something called spousal tax exemption. 7/8 to the children, and using the £325,000 tax-free allowance nil rate band and £175,000 of the net residential supplementary nil rate band, basic terms mean inheritance tax remaining unexempt £353,125, which at a rate of 40% comes to a tax bill on first death of £141,250 in this scenario. Now we have the same scenario with the same value of estate, but you have an appropriate trust-based will, which gives flexibility to provide for the spouse left behind, ensures an Islamic distribution when the time comes, and results in potentially having a tax liability of nothing. So in the first scenario, there was a tax bill, and in this scenario, the surviving wife gets life interest, something called life interest over the assets. Because of spousal exemption, on first death, there is no inheritance tax. On distribution of the estate on second death, given all of the inheritance tax allowances, there is still nothing to pay in inheritance tax. So with an appropriate trust-based will, you do not pay inheritance tax. We've spoken about lasting powers of attorney already, but the Islamic basis of lasting powers of attorney are a compulsory aspect of Muslim estate planning. If you have never heard of them, I can share with you that there are two main types, and also certain specialist businesses or commercial ones can also be set up to help you. Anyone can prepare these on the government website, but it is very difficult to navigate. When lawyers are assisting you, we can advise you on the preferences or instructions to include to ensure full compliance with your faith-based decisions, such as a halal diet and care within the home environment, and Sharia-compliant investments only to be accessed. To explain it in simple terms, the will takes effect when we die. It does absolutely nothing to help you when we pass away if we lose mental capacity. If we have the foresight and preparation to prepare our lasting powers of attorney in health and welfare and property and finance, then we benefit, inshallah, in two ways. UK banks since 2011 are under guidelines to freeze bank accounts of any customers or clients who have no longer have full mental capacity. It does not matter if it's a joint bank account with a spouse. And the banks will say, to regain access to your bank accounts, please go to the UK Court of Protection. This is a process that typically takes about 9 months and can cost anywhere between £2,000 and £3,000, taking into account typical solicitors' fees. And at the end of that process, it's up to the courts and their wisdom to appoint who they feel is to be the attorney. It's not always who you want it to be. They have been known to appoint independent solicitors, which is a legally safe provision, but if you picture the scene, in those circumstances, on each and every occasion, you want to access your own money, you would have to go to these court-appointed solicitors. And usually the solicitor isn't already charging by the hour. I think it's fair to say there's a fee involved each time they pick up the phone or a pen. So if you appoint an attorney husband, your wife, an adult child, in property and finance, in those circumstances, by virtue of that legally binding document, they can seamlessly step in, unfreeze bank accounts, pay bills, manage assets, and you're not subject to that lengthy, costly court of protection application process where ultimately the court decides who is to be the attorney. So hopefully you can see why a property and finance LPA is a very sensible thing to arrange. The health and welfare lasting power of attorney is the other one. Sometimes we become vulnerable and the local authority in their wisdom will come along and say, we think in our wisdom you would be better looked after in professional care or a care home. How much of a consultative process that is with a family member, there's no set science. Different local authorities work in different ways up and down the land. If you have an attorney in health and welfare in place, at that point, the husband or wife can say, actually, my wife, husband's perfectly fine here at home, I will look after them, and that's the end of conversation. And if you're not in a professional care environment, you're not subject to professional care fees. Care fees in the south of England today are in excess of about £1,600 a week, about £80,000 a year. Over the course of 4 years, £300,000, that's enough to wipe out the value of your home. Typically, a married couple are joint tenant owners in a property, which means they both jointly own 100% of the home. Whilst you're both alive, if one is compelled to go into care, if you don't have that health and welfare LPA, then the local authority, the state, will charge you for care fees from your savings. And then once your savings are used up, they will place a charge on your property and accrue on a weekly, monthly, yearly basis relative to how long you spend in care before we pass away determines what's left for your children. So again, the health and welfare lasting power of attorney is also a very sensible thing to arrange, inshallah. If you're in hospital under a schedule of treatment or care, the local NHS trust doctors cannot make independent decisions about matters typically to do with escalating treatment, turning things off. If there's an attorney in place, they have to be consulted. So there is a to-do list for everyone in the course of preparing an Islamic will. With any statutory declaration, if appropriate, to finalise both applicable lasting powers of attorney. If the person is no longer here, there can sometimes be enough time to ensure Islamic probate procedure is followed by setting up trusts or something called deeds of variation. Most importantly, you now have the knowledge to ensure these noble endeavours are completed for yourself and your family members, your dearest ones, the wider community, and inshallah the Ummah. Our mission is to change the given statistics and propel everyone towards a path of success, inshallah ta'ala. If you have any questions about all that we've discussed today, I appreciate it's been quite heavy, but you will also appreciate it's a very important subject and topic. We, as a law firm, will offer free consultations on a no-obligation basis if anyone wants to talk about their own individual circumstances and affairs, and we will give you guidance there. We have a short, conscious of the time, so are there questions that we have today? Yes, brother.
Just a simple question.
Yes.
So, will the will, can it be like simple enough to just say that the person is Muslim, and after his death, the court or whatever, they should follow the Islamic rules for his whatever property or money we have? So can it be simple like that, or they have to specify exactly how many children and what's the Islamic rules say in that regard? So can it be just to follow Islamic rules, make it general, or it has to be very specific?
So the brother, for those of us who didn't catch the question, asked a very good question. In terms of forming the will, can it be a very simple one that identifies as an Islamic will, or is it better to go into shares? There is a bit more. I need to know more about your circumstances to answer that question, brother. But in the best scenario, it's always good to have the Shahada, the declaration of faith, that leaves no doubt that the deceased is a Muslim. But also to provide, explicitly state those shares is also very important for different reasons, especially if you are in this country. So, sorry to sound vague. Yes, you can say a simple, I want my estate to be distributed according to the laws of Sharia, but then you have to employ something called a trust, a discretionary trust, where the trustees appointed will act on your request to distribute this according to those specific shares, according to their knowledge. Hopefully that answers the question. Any other questions, brothers? Yes, please.
Sorry, if you don't have a will in place at the time of death, then what does UK law actually stipulate with regards to how your estate is distributed?
Yes, very good question again, very important question. The brother at the front asked, if you do not have a will in place, what happens? How does the law of England and Wales, the law of the land, affect your inheritance? You pass away as something called intestate, brother, and the laws of intestacy are very specific. Up to a certain value in the estate, a spouse will inherit, then its children. If there aren't any children, other things happen. So there is, again, guidance that we can give you, or you can look up yourself. But it's always important as Muslims to have an Islamic will. Does that answer the question? Any other questions, brothers? Yes, please.
When you gave a couple of examples of what happens if you've got several survivors to your estate. What happens to somebody who passes away who's not married and have children? What happens to their estate? How should it be divided Islamically?
So again, that's the brother asked, if a person passes away without a partner, a spouse, and children, what happens? So again, the Islam, the Sharia, the Quran and Sunnah is very clear about what happens in that scenario. I won't give you a specific answer here now, but there is a specific route to give you guidance here. It's all encompassing. It is all encompassing. Any other questions? Yes,
Sorry, at the beginning you mentioned there's 1/3 which is effectively optional.
yes.
You can do whatever you want with that 1/3?
Yes. So the brother asked, within an Islamic will, you have the option to leave 1/3 to charity or who you choose outside of the prescribed shares of inheritance. You can leave that. So, just repeat the question, please.
Yes. The 1/3. Do you have the option to do whatever you want about it and give it to whichever person you want to?
Yes.
In that 1/3.
Yes. The brother asked, do you have full autonomy over exactly who you want to leave the 1/3 share to? Yes, you do. That is your choices. That 1/3 share can typically be employed in a will to absolve people of their shortcomings during their life, if they pay, if they haven't been up to date with their zakat, if they haven't been to Hajj, and they failed in their other duties. This is an opportunity to appease Allah subhanahu wa ta'ala and get on board there. So yes, you have the freedom to choose who you want to leave your estate to through that 1/3 share. Brother at the back.
What about this 7-year rule where you can give your property to pass on to your children?
Yes.
You've got 7 years.
Yes.
Survive that 7 years.
Yes.
You don't have to pay inheritance tax.
Correct. So, brother there asked a very good question about the 7-year time clock rule, about gifting. So, during your lifetime, whilst you're still alive, if you're concerned about inheritance tax, you can gift parts of your estate to your children typically. And you can bring your estate within the inheritance tax allowances in preparation for when you ultimately pass away. The benefit of doing that is, if you survive for 7 years after making those gifts, those assets do not come into the equation of being considered for inheritance tax. You're clear of inheritance tax. Even if you do not survive 7 years, the rate of inheritance tax is 40%. But because the rate applies on a tiered basis, the longer you survive, the rate comes down. So there is inheritance tax advice that you can seek out. But generally, as a rule of thumb, a lot of people do gift estate during their lifetime, mindful of the inheritance tax position at the point of death. Does that answer the question?
Is there any limit?
There is no limit to how much you can gift. No. If you do pass away within the 7-year cycle, the rules of the state allows for £3,000 a year to gift without that interfering with inheritance tax, but ultimately you can give away as much as you want to, and if you survive the 7 years, that's gone out of inheritance tax. Does that answer the question? But we can speak more after, go into more details.
Sorry, just following on from that question. If somebody gives within the 7 years, are they liable for any other taxes?
No. From an inheritance tax perspective, if you survive a clear 7 years, that amount of your estate is out of the equation. Also, we've discussed that it's important to have a will, but it's also correct to say having just a basic will is not sufficient. If sometimes clients leave all of their estate, husband passes away, leaves everything to the wife, and the idea is when the wife passes away is to go to the children. When the husband passes away, during the remainder of the wife's lifetime, she might go into care, and at that point, because she owns 100% of the estate, there's nothing stopping the government from claiming care fees. The wife might pass away first, and the husband may choose to move forward with his life and remarry. When he remarries, he may predecease the second spouse's wife. And in that scenario, if they've got just a basic will, that new wife becomes 100% owner of all of the estate. Now, according to UK rules, it's at the discretion and kindness of her heart whether she wants to leave anything to the original children, because she's not legally obliged to do so. She may have children of her own from her earlier marriage, and then the first children in that scenario are disinherited. It's called sideways disinheritance. So having a trust will just ensures that, yes, you can aim to leave a estate to the children, but on first death, you don't leave it outright to your wife or husband. They get to benefit for the remainder of their lifetime. But if you should pass away, husband or wife, and they remarry, the first spouse, husband or wife, to pass away, their half of the estate is ring-fenced for the original children. Irrespective of what the surviving spouse does, there is no adverse influence or effect on the first children. So, following on from that, sometimes having a basic mirror will is not good enough. You have to have a trust will. There are different types of trust wills. I don't want to go into too much detail, confusing perhaps, but based on your individual circumstances, how much your estate is valued at, what your family dynamics are, a suitable trust will would be easily identifiable and will be recommended for you to protect your children, inshallah. Does that make sense?
Yes.
Any other questions?
Sorry, I've got a question to follow up on that. That scenario that you just described,
Yes.
how would you protect the wife then? For example, in terms of the timing of the implementation of that will.
Yes.
Let's just say, for example, the husband passes away,
Yes.
the wife's still alive, okay?
Yes.
At that point, would you have to execute that will and say, okay, now we need to sell the house, distribute it 1/8 here, 1 2/3? Would that have to be at that point?
It's a very good question brothers ask here. So what I've just explained, how does that transfer to the scenario where husband passes away, wife is left, you're trying to pursue an Islamic will with designated shares for the children, wife? Do you have to then sell the property, ask the wife to vacate and give the identified shares to the children? No, you don't. With a trust will, what you do is you appoint the wife as having something called a life interest. So they have a life interest, which means they get to enjoy the husband's half of the home, and they would take their 50% ownership of the home. Okay, so in the scenario where there are two homeowners as joint tenants, you sever the tenancy And you still remain joint owners, but you become tenants in common owners. And that's much, much better, because you still remain joint owners, but husband and wife have distinct 50% ownership of the family home. When husband dies first, their half of the home goes into trust for the children. Okay? The children do not get it until the wife passes away. But Islamically, you're complying with Allah's rules. The wife has a life interest, so she can benefit from the husband's estate, the profits, if it's invested. She can move, downsize, and use the husband's half of the home. No children can come along and say, "We want our shares, mother, please sell the home." Because legally she has to stay in the property. But when she passes away, that's when she doesn't become an outright owner of the property. She stays 50% owner, tenants in common owner, but when she dies, the children get her share. But if she was a survivor, or the husband was the survivor, if they've been married and passed away, the half of the home is protected in something called a property trust. So you can achieve Islamic rules of inheritance whilst ensuring that your surviving wife is safe in the property. So
the life interest is Sharia compliant. This concept. Yeah.
The compliance in the Sharia comes to who is to have the inheritance. So ultimately you achieve that, but the way, the mechanics of achieving that within the rules of the land, just, you tick both boxes, inshallah, please bless.
Okay.
Does that answer your question, brother?
Yeah, that's good.
Okay. Any other questions? As I say, if anyone would like a consultation free, no obligation, please leave your details. The office will be in touch. We'll arrange an appointment free of charge at the office, in your home, by phone, by video, and we can inshallah help you meet your obligations there in terms of Islamic estate plan. Jazakallah khair.
On behalf of all the brothers and sisters, and especially the man who trustees of the masjid, I'd like to extend our gratitude and our appreciation and our jazakallah khair to dear brother Syed and his team for kindly enlightening us on this important topic. There's many things to think about and go away with. I'm sure many of us have now got ideas in our mind as to how we will be then therefore planning our wills and estates, so that inshallah ta'ala we don't fall foul of several of these restrictions and constraints, and that inshallah ta'ala our families, when we leave this world, they are looked after as is the command of Allah ta'ala. Allah ta'ala bless the members of Al-Haqlu, and Allah ta'ala bless the brothers and sisters who have stayed behind this evening to listen in, and Allah ta'ala make it easier for us all in this regard. And as the brother mentioned, this is something which sounds morbid when you talk about it, but it's something that is very important. And if it talked about with seriousness and focus, inshallah ta'ala, it means that maybe it sounds morbid and difficult now, but inshallah a lot of positivity and goodness, not only for ourselves in the hereafter, but for our children who will bring behind that as well when we leave this world, and our other family members. And in that way we are doing the best we can as dear loved ones and responsible people to ensure our loved ones are never in any way forsaken or deprived. May Allah ta'ala bless you all. Jazakallah khair once again. Assalamu alaikum wa rahmatullahi wa barakatuh. And of course, yes, please do network, and brothers and sisters, please do, on your respective sides, please do meet the dear presenters, and anything you wish to discuss, please do give your details, and inshallah will be in touch. Assalamu alaikum wa rahmatullahi wa barakatuh.
The man